Hello, and welcome to PubK's 2022 Government Contracts Annual Review. We're thrilled to have more than 3,000 session registrations for this annual review. Over today and the next two afternoons, we'll present 7 additional sessions. We hope you'll be able to join us for most, if not all, of these sessions. But a separate registration is required for each one that you want to attend, which you can still do on the PubK website under the Annual Review tab. My name is Ota Funding. I'm the president of the PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator for this year's annual review. I'm hopeful that we'll be able to convene in person next year. The PubK Group consists of 3 newsletters: PubK Law, PubK Compliance, and PubK Cyber. Many of you are already subscribers to one or more of these publications, and we appreciate your support. Some of you are not subscribers, but I hope you'll consider becoming one. This conference would not be possible without the support of our event sponsors listed on this slide. In addition, in lieu of speaker gifts, we'll be making a contribution to the Capital Area Food Bank, and I hope you'll consider making an individual or organizational contribution. Since the program is held entirely virtually, all attendees will be in listen-only mode, and your video will remain disabled throughout the session. But we welcome your questions. Use the Q&A box at the bottom of your screen, and we'll try to get to as many questions as we can. All the presentation slides, along with the audio, will be available for download from the PubK site. We hope you'll look at that as well. In addition, you can look at our YouTube channel and follow us on LinkedIn. We're also applying for continuing legal education in a number of jurisdictions, and while we cannot guarantee approval, we expect that acceptance within the next few weeks. We'll notify all attendees when those approvals have been received. Finally, if you're interested in obtaining CLA, please look for our poll questions during the presentation, because the state boards require us to verify your participation. Now I'm thrilled to continue day 2 with our session 5 panel on grants and cooperative agreements. Our panel members are Diz Locario with Venable, my partner Jeremiah Centrella from Nichols Lew, and Tom Mason from Thompson Hines. Tom, over to you.
Thank you, Alan. It's a pleasure to be here to bring an update on grants and cooperative agreements. And this year for us has been a particularly busy year in the world of grants. We've started to see a lot of clients asking for counsel with respect to grant flow down clauses. Whether you're a recipient or a subrecipient, the clauses are apt to apply. Whether the swing to use grants more frequently is due to the pandemic, reduction in the government workforce, need for more jobs, the need to improve the infrastructure, all of these things we think contribute to it. And we need to work hard to make sure that we are up to speed and able to provide support to our clients as they encounter a grant, and particularly as it differs from a public, federal, or state contract. The reason I wanted to start with a discussion about grants or contracts is because grants are contracts. And I can tell you this from personal experience when I argued before the Court of Federal Claims in the late 90s, that I was trying to make the point that grants were different, and the judges made it very clear that grants are contracts. So what's the number one requirement for a federal contractor or a state contractor? In my opinion, it's to be responsible. And so when we think about grants today, we think about grants and contracts, and we think about a contractor's obligation and responsibility to be technically and substantively responsible. These are fundamental requirements, and they're the cause for some companies to lose contracts, lose grants, or to be found not responsible and able to perform or get an award. And so grants are contracts. That's where we want to start. And we're at the first slide is showing here, and we're starting to see the agencies award more grants, and we're starting to see the recipients and subrecipients having to deal with different problems than perhaps they were 5 years ago. Now, I put an example on the first bullet here because it's very important that we understand what agencies want. And agencies are going to incorporate policy requirements, needs of the agency, statutory federal acquisition regulation requirements into a grant. And so it's important to see what the agency's objectives and priorities are. And we put the NIH policy requirements citation for you in the first slide. In section 4.1, the public policy requirements and objectives in the NIH grants policy statement is a good resource and a good place to start. Examples of public policy requirements, I call these like socioeconomic requirements that we find in federal contracting, are a few of them are listed here. If you've ever worked on a grant in a life sciences lab, you'll understand the requirements to test animals humanely. There's animal welfare requirements, civil rights protections, financial conflict of interest admonishment and rules. We want our grant personnel, our recipient personnel and sub-recipient personnel to promote American air carriers. And so we have the Fly America Act, you'll see incorporated. And also there's a desire to curb misconduct during research where grant money is expended to perform one research task, but yet we see that another research task is done in addition or to the exclusion of the original intended task. Initiatives, not only to meet government needs, but also socioeconomic policies are advanced by grant performance. This is one of the things that we're going to see with a quick look at the new Infrastructure Act. Let's move to slide 2. And so it's very important to understand what agencies want. And it's very important to understand what agencies think are important. So I included subpart D of 2 CFR 200 to these in the second slide, because it talks about the administrative requirements for federal grants and cooperative agreements. And look at the topical sections that we have here. Standards for financial program management, property standards, procurement standards, performance for financial monitoring and reporting, sub-recipient monitoring and management, record retention and access, remedies for noncompliance, closeout, post-closeout adjustment and continuing responsibilities, collections. These all speak to the fact that grant awardees, grant recipients have the same obligations to be financially and technically responsible as does a company that's been awarded a public contract. I use this as kind of a checklist, if you will. Sometimes the clients want shell matrices, and sometimes clients want to know what they have to do, what practically must they do in order to be compliant with the grant. I use these types of lists of responsibilities, these topical sections to help me in the preparation of and submission to the client of a shell matrix. Let's go to the next slide. So there's 3 things that I wanted to highlight here. If I had to rate the top 3 question areas that we're receiving in the area of grants and cooperative agreement, it would be cost reimbursement, rated orders, and management of intellectual property. So one of the things that you'll notice about a grant, if you get to do support more and more of them, is that there are many grants that are awarded on a cost reimbursable basis. And so what happens when it's awarded on a cost reimbursable basis, the appropriate sections of the FAR are incorporated by reference into the grant clause. And we get into the issue of what's an allowable cost. We get into the issue of cost principles. We get into all kinds of budgetary and earned value management types of situations where we're spending cost in excesses of our performance. And so cost reimbursement grants are, I think, something to highlight for everybody to make sure that you're attuned to the fact that the FAR clauses can be incorporated into grants and cooperative agreement. The biggest issue for the clients that we've talked to have been rated order requirements. And a grant, I don't normally think of a grant as requiring a rated order performance, where DPAS has a certain number of days where performance must be made, and that provision is incorporated in the grant. But yet we're seeing more and more rated orders becoming requirements of grants. And again, this puts the onus on the recipient and sub-recipients to meet the schedule. When there's a rated order in the grant, that means the schedule's not going to be negotiated easily. And the last area is the management of intellectual property. I think this is critical, particularly in the life sciences arena or the product development arena, where the contractor, the grant recipient, wants to retain ownership of intellectual property. If you follow the normal grant clauses, the government will retain intellectual property under work made for hire in many instances. And we have other clauses that would allow the contractor to have ownership. And of course, we've got the Bayh-Dole Act, which, if implemented correctly, will ensure that the grant recipient or subrecipient or a contractor can retain intellectual property rights. And so I highlight these areas because I think they're areas that are of importance and are going to be of continuing importance as we use grants for research and development tools. Slide 4. Okay, infrastructure investment in the Jobs Act. And this is a pretty important act. It was signed into law in November, and it's something that everybody should be focused upon. As you can see by the terms of the slide, it marries up two very important interests. One is to take action to repair an infrastructure across the nation, and the other one is to create domestic jobs for a workforce that needs them. And I think part of this reason it's good to look at this act is the interplay between the substantive provisions of grant performance plus the implementation of the socioeconomic, the interest in expanding the domestic preference requirements, expanding the number of jobs, and these are important aspects of the grant. If we take a look at the Infrastructure Act, we see that domestic preference requirements governing grants are being included in most grants, and they're adding more stringent domestic content. And the Buy American rules are going to be applicable to federally funded infrastructure and public works contracts. A couple of notes, just a couple of examples. Under Buy American Act, you'll see provisions that impose a domestic preference on all infrastructure projects that receive federal funding at the federal and the state and the local levels. In the Berry Amendment, their provisions are drafted to ensure that all PPE purchased by DHS, HHS, VA are Berry Amendment compliant, meaning 100% domestic content. So you can see here the grant being used not only to address a substantive need, infrastructure that needs repair, but the promotion of some domestic policies that are important as well. Slide 5. So the infrastructure bill includes funding for all kinds of grant programs. Some are competitive, some are not competitive. And we're seeing increased funding for grants that have already been awarded as well. The funding will flow mostly through the federal program office directly to the states for the infrastructure work. It's anticipated that the actual performance contracts will be awarded by state, tribal, and local regional government entities. Direct funding along with can be made along with and used with private funding and funding from the states. And it seems to me that we're moving back with some intention to an increase in what I call the PPP projects, the public-private partnership projects, where we're trying to be as inclusive and as responsive as we can. There's some project delivery and finance points that I'd like to make, and just briefly. Alternative contracting methods. We'll see here that there's a relaxation. We noted here a relaxation for the Secretary of Transportation to use contracting methods that might be available to a state and or to a local entity, but would be prohibited under the FAR. A couple that come to mind would be project bundling, design, build, concession agreements that are of a long term. And the most interesting thing from my perspective is the use of other transaction funding. At the local level, each government authority may be able to execute an OTA agreement of up to 250 million. I'm told most of them won't be that high, but that's a pretty high standard, and it would be a nice source of funding to accomplish a lot of things. On the OTA front, from my research, it looks like there's going to be OTA funding available for prototyping, research and development agreements, as well as for some production contracts and grants. Next slide. So what's the conclusion here? I think that grants are a thing to be reckoned with, and grants are going to be treated like contractors. We must be responsible. I'm going to use a lot of A's to summarize what I think we need to do. We need to assess the benefit that we're seeking, the cost, and the effort required to comply with the law as we seek to gain the benefit that the grant funding will provide. Analyze the funding programs and making sure that we take advantage of programs whereby we can be responsible. We want to align the benefits and goals and obligations identified by the funding programs such that we're aligned in our grant performance with our subrecipients and also with our customer. We want to accept and work with other parties, state, local entities who seek common objectives and manage well the resources. We need to adapt practices to effectively manage changes. We need to be able to deal with effective program management and obviously supply chain discipline and management is going to be paramount. And always attention should be paid to cost, schedule, and performance, the three things that will make us successful. And so before I turn it over to Diz, I'll just make one more statement that the contracting activities must be financially responsible. And the grantees, the grant recipients, the sub-grant recipients must also be responsible. And that's the area that I think that focus must be given to ensure we've got responsibility up and down our supply chain, our grant or cooperative agreement supply chain. And with that, I'll turn it over to Diz.
Thank you, Tom. Good afternoon or good morning, wherever you might be joining us. Thanks for joining us today on this grant segment of PubK Law's annual review. Next slide. So Tom talked a little bit about the infrastructure bill. I'm going to go back and talk a little bit about something that hit a lot of contractors and grant recipients a couple years ago, and just kind of give a little bit of an update of where this stands and remind everybody of those requirements. There's a lot of slides in the materials. I'm not going to go over each slide in great detail, but you'll have them as backup materials. So most of you hopefully are aware of the National Defense Authorization, the John McCain bill from 2018 that prohibited certain telecommunications and video surveillance services and equipment, which impacted both the contractor community and the grant community. I'm going to primarily focus on how it impacted the contractor community, but there's information in here on how it impacted contractors as well. Really, that legislation, that bill was designed to mitigate certain supply chain risks that had been identified caused by certain foreign intelligence threats, mainly from certain Chinese actors. Next slide. So what that requirement or legislation provided were certain prohibitions on the use in the context of grants, on the use of grant funds in the context of contracts. It'll be in the context of contract funds, but also a little bit more broad application. But as it related to grants, right here, section 889, section B1, the head of an executive agency may not obligate or expend loan or grant funds to procure or obtain, extend or renew a contract, to procure or obtain, or enter into a contract to procure or obtain the equipment, services, or systems described in subsection A. Next slide. And subsection A is the one that was designed to address contracts, and here at the bottom of this slide is where I kind of summarize that, Part A and Part B. But essentially, it was the prohibition of using what's called covered telecommunications equipment or services as a substantial or essential component of any system or a critical technology as part of any system. And so, next slide. So essentially, the grant terms took this definition of covered telecommunication equipment or services, which includes a host of different Chinese companies, most notably Huawei, ZTE, and some others, and said, look, you cannot use grant funds to procure their products or services. Now, that differs from the contract side, which Part A of the contract side said the same thing, except it said you can't use contract funds to procure those services. So you couldn't really bring those services into performance of a contract. And then Part B was even more broad for contractors only, saying that you couldn't use that equipment or services within your organization at all, irrespective of whether you're using it on a federal contract or not. But the grant side of things is narrower than that. Next slide. So what's important to recognize is it's narrower, but it also only took place about a year and a half ago. And as we're going to talk about, there's been some waivers and some delays that have saved many grant recipients from having to worry too much about this. But the grants took effect, Part B1 there, August 13 of 2020, and then A1A and A1B, those are Parts A and B applicable to contractors. So for grant recipients, about 18 months ago, this took effect. So hopefully this is not the first time you've heard of Section 889. Next slide. So I mentioned some grants or grant recipients haven't had to deal with this just yet, and that's because there is the allowance for waivers, where an agency can seek a waiver from complying with this, and it's no small feat because they have to go to the Director of National Intelligence to obtain this waiver. Next slide. And so this is just a summary. This was codified essentially for grant recipients into the Uniform Guidance, which is that 200 or Title II, Part 200, Section 216, which essentially talks about what I had already summarized, which is that grant funds cannot be used to procure or obtain these prohibited products or services. Next slide. And they also can't be used, well, this is just another provision from 216. Next slide. 471 there at the bottom is the cost principle. Tom had mentioned cost principles, and the cost principle provides that products or services acquired from these prohibited agencies are unallowable costs. So I mentioned waivers, and USAID is probably given one of the more notable waivers, that it will, their guidance in their FAQs is that it applies, on August 13 of 2020. But next slide, they did obtain a waiver. As you can imagine, much of what USAID funds overseas are in areas where Huawei is a very, predominant player in the space. And so they obtained a waiver through September 30 of 2020, which allows organizations to continue to use Huawei under USAID funded grants through that time period. But obviously that is, 8 short months away. So something for folks to keep in mind. In a few minutes, I'm going to ask Jeremiah to jump in because he actually has some interesting information on this as well. Next slide. So the takeaways are, unlike the Part B prohibition, which I just briefly covered, is that recipients of grant funds can still use the covered and prohibited supplies and services, but they simply cannot pay for it with grant funds. So a recipient can use unrestricted funds, but keep in mind that paying for it with grant funds, that includes both direct and indirect. So these expenses, as I noted, Section 471 of the Uniform Guidance provides that it's an unallowable cost. So any costs that go towards these types of services or products need to go into your unallowable cost allocation. And then in the grant context, you actually can use this stuff. The problem is, grant recipients are typically scraping for every dime and dollar they can get. So anything that goes into that allowable bucket is really a disincentive for the organization, because otherwise it has to come up with unrestricted funds to pay for those services or products. Also, the grant side is a little bit lighter in that there are no certification requirements like there are on the contract side. On the contract side, the very specific certifications, and as most of you probably know, certifications lead to potential miscertifications or misrepresentations, which lead to false statements or False Claims Act liability. So there is a little bit less rigidity and liability and consequence there. Important to keep that in mind. Now, one of the things that we've talked with a number of clients over the years, or over the year and 18 months or so, are what other types of things can be done to avoid, this prohibition. As I noted, many of the organizations that are funded by USAID are not here in the United States. They're operating overseas. The organizations may be based here, but their primary operations are overseas. And overseas, Huawei, ZTE, and others are very big players. In Africa, for instance, it's nearly impossible to find telecommunications services from anyone other than Huawei in certain parts of the continent. And so what can you do? Well, some clients have inquired about whether firewalls can be put in place to mitigate those measures. So far, we've not found any guidance to date that would indicate that that's an acceptable means of compliance. But as I noted, Jeremiah actually has some interesting tidbits that he's seen, and so he'll jump in here in a moment. Next slide. So what are some of the takeaways? Well, as I mentioned, the firewalls don't necessarily look like they might be an acceptable means. There's some USAID questions and answers, and here wanted to put this one in here to show what USAID's current thinking is, or current as of last year, and whether or not mitigation measures like encrypting traffic going through ISPs would be an acceptable method. And USAID at that time said, no, to be compliant, you must not use covered technology. And here they say must make the representation at FAR 52204-24 that they're using covered technology in its supply chain, then a waiver must be approved. The technical risk mitigation like encryption does not meet compliance. However, such information could be helpful in obtaining a waiver. So here USAID was taking a very hard line that things like encryption would not satisfy compliance. Next slide. So what does it all mean? As I talked about, on the grant side, it's really about allowance and disallowance of costs. It's not that you can't use this stuff, it's just you can't pay for it with government money. There are no certifications in the grant context. Whether there's an implied certification, I think that's probably a safe guess that the government could link that. This is certainly something that was very well known and publicized by the government. So arguing whether it's a material provision or not, the government would probably have a pretty good argument there. And so I do think that you probably would run up against the potential implied certification theory if you pass through costs that are unallowable. And what happens, if you do pass through costs? Well, there's always the possibility of termination, but also always need to keep in mind the idea of False Claims Act and suspension debarment. Next slide. So what do you need to do? You need to first understand what are the rules that are going to apply to you. Are you under the grant or are you under the contract? You might be under both. And so you need to apply how that's going to apply to your organization. The most stringent is under contract Part B. So if you're a prime contractor, you're going to be subject to Part B of the contractor rules, and that's going to affect your organization completely. So definitely need to assess what rules apply to you as you dive into this. And again, hopefully you have. Next slide. But under a grant, you should be certain you know who you're acquiring products and services from. You probably want to include slowdowns with those folks. You want to make sure that you may even want to put reps and certs into those subcontracts, those vendor agreements, those subrecipient agreements, so you know what type of stuff is bubbling up to you. That way you can pass those costs on. Alternatively, if you know that those prohibited costs are bubbling up to you, is there a different method? Or at a minimum, you're putting those costs in an allowable bucket. So you're excluding those both from the direct costs, but also the indirect cost allocation. And as you know, you're not required under the uniform guidance to have a certification. Certainly agency by agency, they may try to impose a certification, but also there's nothing to say that you cannot impose a certification. So with that, let me pause. Jeremiah, I know you had some updates on section 889 as well.
Sure, thanks, Dizzle. Just a couple of things to keep in mind as we work a lot with USAID and state contractors operating in all these areas. I think two more recent developments. We've had a lot of conversations with USAID's legal team around 889, general counsel, deputy general counsel. They've really struggled with it. But we understand that they have obtained a waiver that will go through 2028. And they're working right now on how that would apply. I think there's an ADS that's already been published actually for the agreement officers and contracting officers. But I think they're hopefully continuing to think about whether a waiver is necessary in the scope, particularly as it relates to contracts, in light of a recent decision that we obtained for one of our clients from the GSA Contract Review Board. We've been sort of making the case that when it comes to these telecommunications ISP service providers that are servicing sort of foreign offices or entities, that sort of thing, really that federal agencies should be able to interpret that in a variety of different ways so that it doesn't require a representation or doesn't reach the prohibition. One of those is making the argument that it's not a substantial or essential component of the contractor systems. The other is potentially, claiming that these are subcontractors. And I think there's difficulty in making that argument, obviously, in some of the technical interpretations, but we've been making it nonetheless. And the GSA Contract Review Board made a decision for one of our clients and told them to reverse an affirmative representation because the GSA Contract Review Board did not view that use of a foreign telco service provider as meeting the prohibition. And it appeared that they're relying on the fact that this telco service provider was essentially a subcontractor and therefore was not required to abide by the prohibition. It was unfortunately not a published opinion and not terribly formal, and it leaves a lot to sort of wonder, but GSA being the primary interpretive agency for 889, it does have some significance, and I know USAID was going to work within the interagency there to try to figure it out. And obviously one of the core issues around all this is, although USAID has a waiver, that waiver wouldn't apply to any other federal agency, and many of our clients are working with, domestically with a lot of different federal agencies, and those agencies would have to get their own waiver. So USAID's does not apply, and that's another issue that they're trying to work through the interagency right now as well. From a practical standpoint, I think we've had a lot of clients sort of make these disclosures to various agencies, and no adverse action in terms of competition that we're aware of. Really, the GSA is the only one to sort of formally respond on our arguments. And we've had some agencies and contracting officers basically just sort of say, don't worry about it, very informally, and then move forward with issuing the contract. So still a lot being worked out, and hopefully this GSA opinion carries some weight. And as they work through it with the interagency, we can see some better interpretive guidance.
Thanks, Jeremiah. I think it'll be interesting to see how the GSA decision gets published. I know that that's not a published decision, and so it's not public, but certainly it's very important information if that's how the government's going to interpret ISP providers.
Yeah, I hope they put something out more formally, and my understanding is that the interagency is working on that to see if they can come up with something that's more formal and more consistent.
Yeah, so I guess the takeaway for folks is, even though this has been in place for 2 years, 18 months for grant recipients, is keep your ears and eyes open, because some new information may be forthcoming here in the next couple months. If not an extended waiver for USAID grant recipients, an interpretation that it doesn't really apply to ISP providers, which would be a huge relief to many grant recipients that I know of. Yep. All right, Jeremiah, I'll turn it over to you for the last segment of our program today.
Thanks, Diz. Okay, well, I'm going to speak about what I term the Whistleblower Protection Act, which is actually a conglomeration of quite a few different statutes, culminating in 2016, 2017, in NDAA provisions that created the current laws that relate to grants and contracts. And while this has been in place since 2017, the reason why I thought it's worthwhile to talk about it this year is because we're hearing about trends around this that are substantially different than I think what we've seen in years past. And by hearing about it, hearing from OIGs over the past year, that they've been sort of inundated with complaints. So they've seen a really significant uptick in retaliation complaints, and they've sort of gotten up to speed with their obligations under the law to investigate these things. So what we've heard is sort of taking away their ability to focus on things that would be a higher priority for them because of the statutory requirements, and they're hoping that word gets out so that folks can maybe avoid having a lot of these retaliation claims. The other reason is, and this is not actually under the same statute, but the other reason being the prohibition on the U.S. government spending any funds with an entity that uses confidentiality agreements that prohibit or essentially hinder employees or professional service contractors and potentially independent contractors from disclosing certain misconduct. And that's a pretty serious prohibition, and it's actually many agencies have that as a representation, a certification that you don't use those confidentiality agreements before you can get an award. And neither of these things really show up in the uniform guidance, which is, I think, perhaps why they fall through the cracks, or have for some time. And we see quite a few organizations and entities that haven't really looked at their confidentiality agreements to make sure they have the appropriate exceptions, or haven't looked at all their form contracts to make sure the confidentiality clause allow subcontractors, vendors, and others to make disclosures, that sort of thing. And perhaps that's why we're seeing quite a big uptick from the OIG is because it's just sort of coming around into the grant space. The other difference when it comes to the whistleblower protections between grants and contracts is there is a mandatory flow down requirement within the statute for contracts, and there's been a FAR in place for some time. But it's less clear when it comes to grants. Although the statute itself makes clear that it applies to grants, to grantees and contractors and subs on both sides, there has not been, as I said, a uniform guidance clause that implements it, and no sort of mandatory flow down requirement. But what we're seeing is that many federal agencies have implemented this in various forms. USAID has a representation certification around the confidentiality agreements, and then its standard provisions incorporate the language of FAR 52-203-17. So we're certainly seeing it being applied to grantees, and it actually has been for some time. But I think it's slipped through the cracks for a lot of folks. So I thought it worthwhile to speak about this. Just make sure everyone's aware, thinking about both the whistleblower protections, what does that mean, what are the obligations, and the prohibition on confidentiality agreements that prohibit or hinder just a broad set of disclosures. Next slide, please. So as I noted, the whistleblower protection applies to employees, personal service contractors, and potentially independent contractors. There's some vagary around that still, and I think arguments could be made both ways, but I think organizations would be good to consider it applying to both. It also applies through flow down to both the contractor or the grantee in this case, and subgrantees as well. The prohibition on confidentiality agreements is one of those prohibitions that has to be flowed down, at least per USAID, has to be flowed down to all entities you contract with. So that means not just subgrantees, but also your vendors, suppliers, and others. So in all of your contracts, you should incorporate both the prohibition on confidentiality agreements that hinder disclosure and the whistleblower protection pieces. Next slide, please. And this is interesting because the prohibition on reprisals essentially protects a very wide swath of disclosures by the protected individuals. And this is broader than I think most folks realize. It just requires that the person making the disclosure has a reasonable belief. And I think for most of you as attorneys, you understand how vague that is, and how unlikely it is to prevail on the notion that a whistleblower didn't have a reasonable belief when they blew the whistle. Essentially, you'd have to have proof of bad faith and what have you. And some of these are sort of the standard mandatory disclosure. So you could say gross mismanagement, that's broader than the mandatory disclosure. Gross waste of funds, also a bit broader, but somewhat consistent. Abuse of authority is a very difficult one. And what we're hearing is the OIG is getting quite a few that might fall under this, where people don't like their management. So it's almost more like a personnel decision, and they don't agree with it, or they think they view management as bullying, those types of things. The substantial and specific danger to public health, fairly self-explanatory, but then also a violation of law, rule, regulation related to federal contractor grant wrongdoing. And this is quite a bit broader than what you might see in the mandatory disclosure rules. So what this protects is quite broad, actually. Next slide, please. And then disclosures can't be made to anyone, of course, but they essentially, those disclosures of misconduct, we'll call it, can be made to members of Congress, Inspector General, GAO, the agreement officer, any of the other federal employees that oversee the award, DOJ, court, but also internally to a management official or employee at the grantee who has responsibility for investigating. So if it's been made to a hotline, or the Chief Ethics Compliance Office, or anyone else who has sort of that responsibility, those disclosures are also protected. Next slide, please. And this is an important slide, and really what's at the heart of, I think, what we're hearing about trends in this space. So all complaints of retaliation are processed through offices of Inspector General. And what's different about a complaint of retaliation under this act is that the OIG is statutorily required to investigate a complaint unless they determine that it's frivolous or was previously addressed in a different government proceeding. And typically OIGs, what we see is, they're limited resources. USAID, I think, probably has around 40 agents globally, and they have their set of priorities, and they definitely don't investigate everything. And often they rely on implementers to do the investigation or their counsel to do the investigation and then take their reports. And they open actually quite a few, and not many comparatively, investigations over the course of a year, formally open investigations. But when it comes to retaliation, they are now mandated to open an investigation and to conduct a full investigation and to provide their report within 180 days unless there's a reason to extend. And the other thing that's different is that the OIG has to share the report with the grantee and the agency, but they can't share any information that would give away who the whistleblower is within that. Next slide, please. And then it's up to the head of the agency. So in many cases, it would be the suspending and debarring official to decide whether or not there was actually a violation. So whether or not there was retaliation. The agency at that point can mandate that the grantee take a number of steps, including reinstating the employee back pay and really remedying the situation in full. And if the grantee doesn't comply, the agency can file for injunctive relief in court. And if the agency and the OIG do not take action, there's no decision within the time frame specified, then the employee can actually go to court themselves and request a jury trial. Next slide, please. So there are some significant pieces coming out of this. I think most importantly for everyone is to really think about those confidentiality agreements. I think it's probably not the majority of organizations that haven't really reviewed all of their confidentiality or NDA clauses across all of their templates to make sure there is the appropriate caveat for disclosures authorized under the Whistleblower Protection Act. And they're making representations and certifications when they get those awards, at least with the federal agencies we're aware of, that they do not use those confidentiality agreements. And those come up in the context of federal investigations around this. So that leads me to the second thing, which is obviously when you have situations that involve potential retaliation and reports to the OIG, just sort of be aware that the OIG is going to be under a mandatory obligation to investigate, and they cannot share any information about where that complaint is coming from. So I think there are likely quite a few organizations who've been the subject of these investigations, but maybe didn't even quite know it, at least not for some period of time. So what should you do now to sort of prepare? Well, I went through a couple there. I think make sure that your employment agreements, your policies, your HR manuals, posters, what have you, all incorporate the required disclosure of whistleblower rights under the Whistleblower Protection Act. Those are different from the standard that you might see EEOC or others. So take a look at what's required in terms of your obligation to inform e-members, which includes an obligation to inform them in the local languages. make sure that your subcontract, subgrant, supplier vendor agreements all include the mandatory flow downs, both of the prohibition on confidentiality agreements that hinder and on the whistleblower protection piece. And then make sure that all of your agreements that include any type of confidentiality or non-disclosure clauses include a carve out for protected disclosures. Next slide, please. The other thing is, of course, just sort of the standard good retaliation prevention measures. So training HR team and their responsibility and making sure that human resource decisions are not being made with any tie towards retaliation. That's obviously sort of the best step you can take. But I think given the breadth of what types of disclosures are protected and the conduct involved, even the most well-intentioned and best organization that is likely to face potential complaint around this. The other thing is obviously studiously abiding by mandatory reporting requirements. One of the most useful things would be if you've already reported whatever conduct it was and it's been investigated and then someone claims retaliation, there's always the potential that then you would fall under the exception. Maybe not, but certainly the best thing you can do when somebody goes and complains is say, we've already reported that underlying conduct to you and we've closed the investigation. So just one more incentive to do that. The other thing that I think is very important, we often miss, is the importance of confirming with insurance brokers and carriers that the organization has insurance cover for dealing with both the OIG investigation and the potential claims in court from the employee or from USAID and the remedies. And this is particularly important now because many insurance carriers have started adopting, it's almost now sort of just standard market term, adopting broad-based exclusions or self-insurance requirements and very high deductibles, what have you, for any claim that involves potential reimbursement of U.S. government funds, and they're trying to even interpret that much more broadly. So right now there would be an open question as to whether or not most insurance policies would cover one of these claims. The other thing is that you want to always make sure that your insurance policy has very good language in terms of when coverage kicks in when you face a federal investigation. And we see a wide breadth of different policies, often from the same carrier, depending on how well the insurance counsel negotiated, where coverage may kick in as soon as the OIG calls for some, and for others it doesn't kick in until the investigation is done and you're essentially a court filing has been made. So really another good reason to check on those policies and make sure there's coverage. With that, I will end my portion and hopefully that we've got just a couple of questions.
Gentlemen, Diz, Jeremiah, Tom, thank you very much for a comprehensive review of what's going on in the grants world. And next time I'm going to track how many times you say grants and contracts. We're bringing those two systems together closer and closer. So they'll have to continue to watch. And amazing how 889 continues to dominate the conversation in this world. Again, a big thanks to our panel members for their outstanding presentation. Let me again thank our event sponsors for their support on these next two slides. I'm glad to have a little voice back. I apologize for that earlier. As a reminder, the slides will make available to you. We'll let you know when all the slides are available for the program and when you can download them and how to access them. You can also follow us on YouTube and bookmark our YouTube channel and follow us on LinkedIn. Thank you.